Employee confidentiality agreements can be enforced without new consideration. A federal court in Pennsylvania has held that a confidentiality agreement signed 5 months after an employee was hired can be enforced after the employee leaves, even if the employee received no consideration other than continued employment. West Shore is a home remodeling company specializing in windows, doors, and bathroom renovation with about 30 locations in 15 states. P.J. Fitzpatrick, LLC, is West Shore's competitor. Both companies do business in Pennsylvania, New Jersey, and Maryland. West Shore's confidential information includes details about vendors, materials costs, utilization methods, and procurement strategies. Designated employees may access this information only on a need-to-know basis, using a password. They're prohibited from downloading this information to a personal device or forwarding it outside the company. West Shore also requires employees to sign non-solicitation and non-disclosure agreements to further protect its confidential information and trade secrets. West Shore hired Michael Grazer in 2018. 5 months later, he signed an employment agreement with the company that included non-solicitation and confidentiality provisions. Grazer worked as West Shore's procurement manager, a high-ranking position responsible for overseeing the sourcing of materials for the company's projects. Grazer resigned from West Shore in 2021 and became Director of Procurement and Inventory Management for Fitzpatrick. In 2022, West Shore discovered that Grazer had forwarded 3 emails with the company's confidential information and trade secrets from his work email address to his personal email accounts a few weeks before he quit. A West Shore vendor tried to email Grazer at Fitzpatrick in 2022, but accidentally used his old West Shore email address. In the email chain, Grazer corresponded with the vendor about information West Shore claimed he only could have learned through his work with West Shore. West Shore sent cease and desist letters to Grazer and Fitzpatrick, then filed suit against them. Restrictions imposed after an employee begins working are enforceable only if supported by new and valuable consideration. Normally, noted the court, mere continuation of the employment relationship isn't enough consideration. However, the court concluded that continued employment is sufficient consideration, based upon distinctions Pennsylvania courts historically have drawn between discrete non-disclosure agreements and non-compete or non-solicitation covenants. The court also found that West Shore took reasonable steps to protect its confidential and trade secret information and had pled a prima facie claim for misappropriation of trade secrets by Fitzpatrick. Let's enforce your NDAs. Visit us at www.eonlaw.com. Eon Law. Unleashing Genius.